deferments and other tax effects.
And folks, before Keith, when we cut you off real quick, we are going to record this to post it on the SBDC website for on demand. So it may ask you to accept, go to the recording of that. If it does, just go ahead and click yes, and we'll move on with the presentation. Thank y'all.
Okay. So jumping into our first area, the Paycheck Protection Program. These are loans that have a forgivable component to them. The applications are going to be in through June 30th of 2020. That February 15th through June 30th period is an important one in the program. Though when we're looking at time periods, we look at 4 or 5 different time periods, depending on where we are in the legislation. Eligible expenses for forgiveness include an expanded definition of payroll, rent, mortgage interest, and utilities. We'll go into each of those in a good bit more detail. Okay. So payroll costs that can be include salaries, wage commissions, and similar types of compensation, cash tips and equivalents. This becomes pretty important in our clients that are restaurants. PTO, severance, group health benefits, including premiums, retirement benefits, and state and local taxes assessed on the compensation. For sole proprietors or independent contractors, we're going to look at wages, commissions, or net earnings from the self-employment. This area has not been as greatly defined by the regulations yet, as the applications for these are just starting today. In all of the salary areas, we cannot exceed $100,000. The independent contractors, it was originally believed would be included in the definition of payroll cost for businesses. The regulations have since changed that, and independent contractors will now file their own PPP loan applications. What's not included? So we're not going to include the excess over $100,000 in compensation. We're not going to include federal income taxes. We're not going to include payments for any employees whose principal residence is outside of the U.S. That principal residence definition is going to be similar to that's used in the IRC or the Internal Revenue Code. Basically, we're going to look for somebody to have the intent to stay somewhere indefinitely, and then a test we'll look at is, are they there for greater than half the year? Also included is sick leave and qualified family leave that's covered by the credit under the Families First Coronavirus Act. We'll get into that a little later. So how are these loans calculated? We're going to take that expanded definition of payroll. We're going to average it out for the last 12 months, get a monthly average, and multiply that by 2.5. The amount cannot exceed 10 million. These are only going to qualify for those that can traditionally qualify for SBA loans. That's going to be the greater of less than 500 employees, or the SBA set standard for the industry. Good example of this is newspaper industry can have up to 1,000 employees. For companies that begin with NAICS code 72, the number of employees is going to be looked at per physical location. Affiliation standards have been relaxed for these. These are primarily hospitality industry. So restaurants are traditionally going to fall into place here. I'm sorry, it appears I'm having trouble with the presentation. Dave, am I not presenting?
No, you're back on. You had a quick little blip there, but you're good to go.
Okay.
We did have a question there. What about overtime calculations? How does that impact the calculations you're talking about now?
Overtime can be included. So it's actual wages that were paid. Overtime is includable there. When we're looking at this SBA qualification, we're going to look at both full-time and part-time employees. We're also going to be including affiliation standards. So there are numerous entities with similar control interests or similar controlling parties. It'll likely be included. Additionally, sole proprietors, independent contractors, and self-employed individuals are going to be eligible as well, as we discussed on the prior slide. So some other qualifications that are there is the business has to have been in effect prior to February 15th. This is a reduction of the 1-year requirement that's traditionally exists for SBA loans. And you have to have had employees which to borrow paid salaries and payroll taxes, or 1099 independent contractors. Even though those 1099 independent contractors are no longer included in that payroll definition, this is where we're seeing some contradiction between the initial law and the regulations that have followed. Loan terms, the payments are deferred for 6 months. There are no SBA fees, collateral requirements, or personal obligations. There are no prepayment penalties. So ideally, if all of the funds are not used and the total amount is not forgiven, it can be paid off right at the end. One of the big key differences is there's no need to show that no other credit was otherwise available. Traditionally, if someone had an open line of credit with availability on there, they could be barred from taking such loans. That has been waived. As most people know, we're applying with any qualified 7A lenders, mostly your banking relationships. Most banks are taking these applications, though there have been a few holdouts due to some ambiguity with regulations. These are different from EIDLs, which are your economic injury disaster loans. Your EIDLs right now are administered directly through the SBA, though there is talk of them potentially being administered by 7A lenders. Treasury loans are available for companies too large to qualify for SBA. So unless have a different industry standard, and let's say you have 800 employees, you may not qualify for these PPP loans. There is a section in the CARES Act, Section 1109, that allowed for a similar program to be run directly through the Treasury, and it included forgivable expenses. That did not actually happen, though. A loan package has been provided for companies with under 10,000 employees. However, it's not forgivable, and it matures over a 4-year period. But those loans are available for people who don't qualify for the PPP loans. That's as of yesterday. Loans are non-recourse. We have a 2-year payback period. It was originally a payback period not to exceed 10 years. This has been reduced by the regulations to a 2-year payback period. And an interest rate not more than 4%. The interest rate right now is 1%. Additionally, these loans don't count as a duplication of benefit. So just because you get these loans doesn't mean you're not going to qualify for other potential grants. Loan forgiveness. So this is the most important part of these loans, and the primary purpose for most people taking these loans is once the loan funds, we're looking at the first 8 weeks from funding. We'll look at the payroll. We'll look at mortgage interest or rent obligations. If those obligations were entered into prior to February 15th of this year, and utility payments. It is important to note that if you sign, a new rent agreement on March 1st, those rent obligations are not going to be forgivable. It's also important to note that the regulations are now requiring that your mortgage interest, rent obligations, and utilities do not exceed 25% of your forgivable amount. They want to see at least 75% of this forgivable amount going towards payroll. Once you've calculated how much of the funds have been spent properly for forgivable expenses, they're then going to be subject to two reduction calculations, the workforce reduction rules and the salary reduction rules. These are probably the most critical and most confusing pieces of the legislation, but you can have a scenario where if these are not done properly, somebody could spend the money on properly forgivable expenses and still end up with less or no forgiveness on the loan amount. For the workforce reduction calculation, we're going to look at the total forgivable amount that we calculate, and then we're going to take the average number of full-time equivalent employees. And it is important to note this is full-time equivalent employees. Employees have numerous definitions throughout the Act. Sometimes it includes part-time, sometimes it does not. This is one where it does not. So we take the FTEs on average for the month during the covered period, which is February 15th through June 30th of 2020. And then we use that as a numerator. And the denominator, we're going to take the average of full-time equivalent employees, again, per month, for that same period for 2019. And we're going to multiply the forgivable amount by that amount. Forgivable amount cannot go up by these calculations. It can only go down. Simple example would be if you currently have, or during that period, if you currently had 7 full-time equivalent employees, and then last year for the same period you had 10, you would only have a forgivable amount of 70% of the forgivable expenses. We can use different periods for new companies or seasonal companies as well. Next, we get into the salary reduction calculation. This is where we're looking at each individual employee during the covered period, and we're looking to see if their pay has gone down in excess of 25%. Every dollar over that 25% reduction is going to be a dollar taken off of the forgiveness calculation. This is going to be an area too. The PPP loan program is more complex than most people are making it out to be. And just to give you an idea, the IRS has recently, or is looking to hire an additional 2,000 people for a fraud division for these loans. So they're anticipating a lot of fraud in these areas because of how complex some of the information is. Both of these calculations, when we're looking at our full-time employees or those that are making under an annualized rate of 100,000, there's going to be significant documentation required for the forgiveness. You know, canceled checks, 941s, a lot of the documentation you're having to provide on the front end. And decisions for these are required within 60 days of the application to the lender for the forgiveness. The lender is doing both the initial application and the application for forgiveness. They're in charge of that. That's not actually going to the SBA. One really important piece of the legislation, though, is the forgivable amount of the loan is a non-taxable event. This would otherwise be considered ordinary income and would generate fairly large tax liability. So we're going to go into HR 6201. These are.
Before we switch over there, Keith, we got a couple questions.
Okay.
I know that, Michael, you say a company uses 1099s as their labor. I understand that is not I understand that what is paid to a 1099 is not eligible to be used in the PPA calculation. His question is, if the company only has one person, the owner, what does he use for the payroll for the calculation? Gross revenue minus expenses or the COG?
Yeah, so this is one of those where we're still waiting on some regulations to come out. Those self-employed individuals are just today able to apply. And quite honestly, the regulations are not out. If you're filing a Schedule C, I know most banks are accepting that as proof, and they're likely going to look at your net operating income to set a portion. What's not clear is how they're going to determine the forgivable amount. And it's important to note too that some banks are not accepting distributions as described on K1s. So, but seem to be accepting Schedule Cs. So there is an important distinction if you have additional partners as far as that goes for the owner compensation. Some banks are viewing, and again, there's so much ambiguity in the regulations. Some banks are viewing owner compensation and including it in the payroll. Others are excluding it from it.
And that kind of dovetails into a question we have from Julie. She sees some frustration as to what banks are doing with changed applications. Asking S corps to include 1099, asking others to include overhead expenses. Would you comment a little bit on a variance in application process from bank to bank? How it's not uniform? Comment on that a little bit.
So the fact is, this is a very complex process that was put together very quickly, and when it was rolled out, it was not complete. Regulations have been coming out and guidance from the Treasury and the SBA have been coming out on these and are continuing to come out. But that is what's causing the banks to send, updated applications and ask for different things, especially if you applied on the first day. You may have received 2 new applications after you submitted your original application. That's not necessarily at the fault of the bank, but more as a recognition that the system really wasn't complete at the time it launched. And the banks are getting set as far as what they now know they want to look at. It's just not consistent across the board.
And Julie had a follow-up question also. She wants to know what constitutes a full-time employee for the purposes of PPP.
Yeah, so that's going to be included in SOP 5010, which is a statement of position. So if you look up, you can Google SBA SOP 5010 5K, and you'll find the definition, I believe it's in there, of a full-time employee equivalent, but it goes along with hours.
Great. Yeah, I think we're caught up on the questions. If you want to continue. Thank you, Keith.
Okay. So concerning sick leave and family care leave that we discussed a little bit earlier, these were covered in HR 6201. This came out prior to the CARES Act and was meant to cover pay for individuals who were either taking care of their families or were sick as a result of COVID-19. It applies to employers with less than 500 employees. The employees must have been employed for 30 days, and if so, it grants paid leave to individuals who are caring for a son or daughter under the age of 18. If the school or place of care closed due to a declaration, so when the shelter-in-place orders went into effect, this got triggered. But the employee also has to be unable to telework. It can't just be they choose not to telework. If those requirements are met, there is no pay for the first 2 weeks. The second part of the act takes care of the first 2 weeks, and we'll get into that. But the following 10 weeks is paid at no less than 2/3 of the regular pay rate, up to $200 per day, up to an aggregate of $10,000. This language is mirrored in the credit that the employer qualifies for. So the intention is to keep the employees paid, but not necessarily have it hit the employer's bottom line. From a cash flow stance, though, because this is a refundable credit, there is some float. The next part of it required 2 weeks of paid sick leave for an employee who's unable to work due to, and there's 6 factors. The employee only has to hit one of the 6, but which one it is makes a difference because it makes a difference on the pay. So the first 3 include if they're subject to a government quarantine. The next one being if they're advised by a healthcare provider to self-quarantine. Or the third is if they have symptoms of COVID-19 and were seeking medical diagnosis. So especially early on, the testing was taking 10, 11, 12 days to get a diagnosis. During that period, they would qualify for this sick leave. The second 3, or the last 3, include caring for an individual as a result of one of the first 2, or again, caring for a son or daughter if the school or daycare is closed. So this covers the first 2 weeks from the prior section, or if they're experiencing any other substantially similar condition. So this is someone who had symptoms but may not have been seeking a medical diagnosis. The payment is different than if they're actively seeking a medical diagnosis. So for the first 3 reasons, we're looking at full pay, not 2/3, but full pay, at an amount not to exceed $511 a day, or an aggregate of $5,110, 10 days in a work week, 10 days of pay. The final 3 reasons qualify them for 2/3 of a pay rate, not to exceed $200 or $2,000 in aggregate. The final piece of this bill includes a refundable credit for qualified sick leave or qualified family leave. Similar credits are available for self-employed individuals. As far as that goes. Okay. So we talked about the U.S. Treasury Management Authority. These were for the loans that are for entities that have greater than 500 employees, so they don't qualify for the PPP loans, but have less than 10,000 employees. These are our mid-cap companies. The original legislation provided for nearly identical rules as the PPP, including the forgiveness. It's not how it's being implemented. Regulations came out yesterday concerning this. The loans are going to be available to these companies. They're just going to be payable on a 4-year term. Again, these are for businesses that are in that mid-cap area, so 500 to 10,000 employees. They also have a section for entrepreneurial development. These are creating grants for SBDCs and women's business centers for training, education, and advising for businesses that have been affected or closed due to the virus. There were certain grantings that were made for the EIDLs. If you're not going the PPP route, or if you were doing an EIDL, prior to April 3rd. Again, we had the waiver of the prohibition if you had availability of credit elsewhere. That's a huge waiver. Made them available to a lot more companies. Waived personal guarantees on amounts less than $200,000 on these EIDLs. And it also waived the 1-year business requirement similar to the PPP loans, where it was February 15th is now the date, and had express advances for up to $10,000 on these loans. These loans for people, again, who received them prior to April 3rd are often being rolled into the PPP loans and refinanced through those PPP loans. So there's not a direct prohibition, but the way having both of these loans works is fairly intricate and is going to be fairly specific to the individual business. Okay. So we'll get into some of the unemployment benefits. The CARES Act created the Pandemic Unemployment Assistance. available through the end of this year.
Before we
Provide-
change gears on that too much, Keith, we got a couple questions on it, and I'll read them out to you since you're presenting. So Victoria says that are you saying that they're delaying the PPP loans for businesses that included their monthly owner's draw? She says she's an accountant with 2 full-time employees. She's in the same boat as a lot of the clients.
I'm not saying that. What I'm saying is individual banks are handling them differently. So it's a question for the banker that you're dealing with.
And we're seeing a lot of variance as to what's going to be an acceptable, basically a loan to originate for one bank is not necessarily within another bank's kind of scope of what they're looking for to as a customer. And that's going to be kind of a construct of giving the banks the individual ability to accept a client or not on their own volition.
Correct.
A lot of times what you're going to see is perhaps one bank accepting a client where another bank's criteria might be totally different or less restrictive or more restrictive. It's kind of the nature of this program as it allocates the loan process amongst all the banks in the country, any 7A lender. Julie has a follow-up question. Are you saying if the EIDLs that were submitted in March were not funded by April 3rd, they aren't getting them? ?
No, that's not what I'm saying. I'm saying they're likely still being processed by the SBA. There is going to be a question, and it's going to adjust the calculation for the amount you qualify if you're accepting a PPP loan. But in addition to that, some banks are having you make representations that you won't be taking additional SBA loans during the duration of that loan, or at least through the end of the year, and that could potentially prohibit it. Really good reasons to make sure you're reading your loan documents.
And really, this is really paramount to stay on top of the regulations as they evolve. What was true yesterday may not be true today. We've seen several times where loan applications have been, scrapped in favor of a new application, only to be scrapped in favor of another application 72 hours later than that. So it's a very, very fluid situation. And what's true today might not be true tomorrow. Frank asks, will you be able to reduce your federal payroll tax payments by the amounts you are paying for the sick/family leave? And I'll ask that again, Keith. Frank asks, will you be able to reduce your federal payroll tax payments by the amounts that you are paying for the sick/family leave?
Yeah, so we're going to go into the payroll tax deferment and reductions a little later.
Also,
in the
Frank,
presentation.
it's very difficult to speak in absolutes with these. So if you guys have any specific questions on specific line items for some of these tax credits, they're going to be very, very situation dependent. So we can speak in generalities, but it's going to be very hard to tell you with absolute answer as to what will and will not be reduced through the credits portion of it.
Correct. And the federal portion has been an area of concern with these because the credits are not 100% moving in that direction. So, but we'll go into that in a little more detail a little later in the presentation.
Great.
Okay.
Thanks, Keith.
And understanding how the tax credits that are available and tax deferments that are available under the CARES Act interact with the multiple parts of the CARES Act is very important. There are certain areas where payroll taxes are deferred for the year and, will be paid in 2021 and 2022. But those deferrals aren't available if you're taking forgiveness under the PPP loans. So failing to realize that and know that can end up with significant penalties and interest. So important to understand how the pieces work together as well as just what the pieces are. This is one reason where it makes me cringe a little bit when people talk about the PPP program being easy. The amount of regulations and the amount of pitfalls that are in the act itself can be disastrous if tripped. So you need to be cautious in those areas. Okay, getting back into unemployment benefits. What it really did was create potential benefits for people who usually wouldn't be eligible for unemployment benefits. These include self-employed, independent contractors, people with limited work histories. The idea was to keep everybody capable of having a livable wage. The benefits have been increased by $600 a week. Those who aren't qualifying for traditional unemployment may be restricted to that $600 a week. But it's extended to both traditional unemployment, pandemic unemployment assistance, and it's for up to 4 months. Louisiana, that portion of unemployment is supposed to start funding on Monday. I believe last time I heard the governor speak on it. But applications that were in earlier should receive the back pay. Federal funds are also eliminating the first week waiting period if the state waives that first week waiting period, and that's through the end of this year. It's also providing funding for the unemployment offices to hire and rehire staff to hopefully process these claims quicker. We're seeing historic numbers of filings this week. I saw or I guess as of last week was the second highest week, only to be beat out by the week prior for unemployment claims. Also provides potentially for additional weeks that aren't usually covered under unemployment, and can also cover reduction in hours, but only for states that either already have that program in place where the federal government's funding 100% of it through the CARES Act, or for states that wish to begin those reduction in hour programs where the federal government's funding 50% of it, and it is based on a prorated benefit. Now we'll jump into some of the individual rebates. These are the $1,200 checks you hear about. Subject to an AGI limitation, though. AGI is going to be your adjusted gross income. $75,000 for individuals, $150,000 for married couples. You can't be a dependent of someone else. Have to have a valid Social Security number. You do not have to file a tax return, though. Those Social Security recipients are still eligible. In addition, there's a $500 addition for each independent. Right now, the IRS is planning to use the 2018 tax returns or 2019 if you've already filed. Planning on doing direct deposits. If you do not traditionally have your tax return direct deposited to you and it's not on file with them, printed checks are going to be substantially delayed. And there was talk of having a place on the IRS website to update your checking account information for direct deposit. To my knowledge, that has not actually been completed. For those that are over the $75,000 or $150,000 AGI limitation, there's a reduction by $5 for every 100 that it's over. And the rebate runs out at $99,000 or $198,000 for married couples. The retirement account withdrawals is a section that is being fairly overlooked, but is pretty powerful in the CARES Act. For qualified retirement accounts for individuals, and we'll go through what qualifies you for these withdrawals. But withdrawals can be made up to $100,000 without the 10% penalty. And the taxes from the income of such withdrawals are paid over 3 years. And the reason why that's a 3-year period is because there's the ability to recontribute those funds over that 3 years without paying the tax on those distributions. The requirements are fairly broad. So it works for individual diagnosed with the virus, or if a spouse or dependent is diagnosed with the virus, or in the third one is kind of the catch-all. So if you've had adverse financial consequences as a result of the quarantine, most on this call probably have. You've been furloughed, laid off, had a reduction in hours, unable to work due to lack of childcare, or if you've had a closing or reduction in hours of a business that you own and operate due to COVID-19. Any of those reasons are going to qualify you for these penalty-free withdrawals from a retirement account. And that's fairly powerful because, again, there's generally that 10% penalty, and the ability to put it back over a 3-year period without paying on the gains is fairly substantial. Nonprofits have not been left out. Nonprofits can apply for, so 501c3s can apply for the PPP loans. In addition, they've taken off some of the contribution caps. So cash contributions up to $300 are allowable without itemizing. For individuals who are itemizing, though, the 50% AGI cap has been suspended for 2020. And there's been an increase for the corporation AGI cap from 10% to 25%. So again, some pretty powerful tools for nonprofits to raise money and for individuals to take deductions. Employee retention credit. So there is a refundable payroll tax credit that is for 50% of the wages paid to employees during this COVID crisis. For employers with less than 100 employees, these limitations don't kick in. There are certain limitations for larger companies that have greater than 100 employees. They're going to have to prove that there's been a full or partial suspension of activity due to the COVID-19 shutdown order. Good example of this would be a restaurant no longer has seated service. That's a partial shutdown, right? They may still be doing takeout, but it's a partial shutdown. Or they'll have to show gross receipts have declined 50% compared to the same period. If your business is closed during that period and you're continuing to pay your employees, a 50% decline is pretty easy to show. You've had a 100% decline. And then the final one is you're covering employee payments, providing services unrelated to COVID-19. So they don't want to necessarily supplement for people who are continuing to make money or making money directly as a result of the COVID-19 virus. But they do want to assist for people who are having their employees continue services that are completely unrelated. They want to help push those forward. There is a cap on the first $10,000 paid to each employee. So, $5,000 credit per employee cap. And this is during the period of March 13th through December 31st, if you're wondering what the crisis period is.
And Keith, we got a little batch of questions here. Probably a good time to start taking a few of those off.
Okay.
Carolyn asked that she says she applied for EIDLS on March 30th. She called the SBA on April 8th, was told that she'd be called by a loan officer in 3 weeks with the SBA, that she needed to do anything else because of the changes. I think you probably need to talk to your bank that you applied with, unless you try to apply through the SBA online. You should probably try to independently follow up and be proactive with that. There might be some additional documentation that they'll need, but that's going to be a very individualized basis.
Yeah, so she would have applied directly through the SBA because currently the banks aren't doing the EIDLs. But what you should be careful of is if you're also applying for a PPP loan, you just need to very much read what you're signing. So read the covenants that are associated with the loans and the loan documents to make sure there's no prohibition on you accepting the EIDL funds. Additionally, when you are contacted by the SBA concerning the EIDL loan, you will need to update them on, if you've received a PPP loan in the interim. But disclosure is your friend in these instances.
Sure. And of course, if you guys have an attorney, bring it to them to have it reviewed before you actually sign anything. It's always helpful.
Yep.
Julie Long, appreciate the honesty. Thank you, Julie. We appreciate you. Part of earlier SBA webinars talked about how streamlined it was going to be. Isn't that how it always supposed to go, right? Nothing's ever easy, and love, death, and taxes, as they say. So we know how frustrating it is. I know the 1099 language was very frustrating, was for us as well. There's some very contradictory language in some of the Q&A and administrative guidance with the law. So we're frustrated by that as well. But that's one of the reasons why it's so pertinent to have eyes on these sorts of things, and it's very difficult to go at your own. So thank you for your comments, Julie. Michael says the $600 a week to July 31st is proving to be a disincentive to employees returning to work. Well, you're right in that. That's going to be a balancing test that people will have to take. He says, will employers in Louisiana have to file the Form 77 with LWC to turn off UE benefits?
Yeah, so that's not clear yet concerning the benefits. Quite frankly, the states are trying to keep up just as quickly as everybody else is with this. There is a requirement that people actively be seeking employment who are on unemployment. So offering the job back to an employee or to rehire an employee should trigger an event that would stop the unemployment insurance. That being said, the unemployment insurance or employees applying under the federal act should not affect your rates, and you are going to be stuck in a situation where the employee or the state is only going to know that the employee's offered if you're telling them. So yes, I understand that some employees would rather continue to get paid as much, if not more, than they're making for sitting at home. And that is going to be difficult, but there are mechanisms in place to kind of force the hand, though that's not the ideal way to do it, right? Hopefully.
And Michael, keep in mind that throughout this process, LWC is really swimming in the deep end with this stuff. So they have a reduced workforce. What we're seeing is a lot of denials in benefits, which probably should have been approved. So that's going to clog the appeals process. So this is going to be something that you'll have to actively and proactively stay up on and monitor yourself and be a prudent administrator, because LWC, they do a good job. They stay on top of things most of the time, but with this process, they are extremely overworked. So I would not rely on them to independently turn off anything or make proper computations for anything. So definitely stay on top of it yourself.
And Dave, in interest of keeping up with and finishing the rest of this, why don't we move forward and we'll address as many questions as we can at the end.
There you go.
Okay, so payroll taxes. There is a deferment through the end of the year on the Social Security portion for employees. This deferment is not eligible to you, and we touched on this briefly, but it's not eligible to you if you're taking the forgiveness portion of a PPP loan. So if you're not, this is a great source of cash flow. But if you are, you don't want to defer this and then figure out, a year from now that you weren't supposed to be deferring those taxes, because you could get hit with, some penalties and interest there. The payroll or the withholdings that aren't paid are going to be owed in 2 equal payments, so half at the end of 2021 and half at the end of 2022. Modifications for net operating losses. This is another really powerful section that's being overshadowed by the rest of the act. But for any individuals that had losses generated in 2018, 19, and 20, Those losses can now be carried back 5 years to offset income. You would file an amended return and would potentially be receiving, or would likely be receiving, a return from the IRS. Another really good way to generate some cash for entities that have gone through, substantial losses in 18, 19, and 20. This is 5-year carryback from that year. Applies to corporations, pass-through entities, and sole proprietors. So really all entity types. And then final section, just really brief. There is a student loan relief section. It defers student loan payments and interest through September 30th of this year. No penalties, and it doesn't count towards forbearance periods for people who are taking use of this benefit. In conclusion, there are a lot of really good functions in this act. A lot of it seems straightforward, but as the regulations have proven or not, we would heavily recommend that you're having proper accounting and legal counsel review all of your information. We know the government's assuming there's going to be a lot of fraud in these areas. They're ramping up teams even now at this point to start looking for such fraud. Additionally, you don't want to run into an instance, and we had a client the other day that I'll give you a good example of, was going to qualify, and she was trying to decide which to take, an EIDL or a PPP loan. And she was going to qualify for a $600,000 PPP loan, but her business was not open. So she was going to be bringing back employees, but not generate revenue. And she couldn't bring back her full staffing. She was only going to bring back a third of it. Well, the problem is, under the reduction calculations in the PPP loan, she was only going to end up qualifying for $200,000 of the $600,000 she was going to spend to be forgiven. So at the end of it, she was going to end up with a $400,000 loan that was not forgiven, that was going to be amortized over a 2-year period. She was going to end up with a $17,000 a month hit to her cash flow. And this would have been disastrous for her business. She was a good example of taking the PPP loan was not in her best interest in that instance. And those are rare instances, but when they hit, they can really hit. And had she not been guided to realize that, it could have been disastrous and would have likely shut down her company, 6 months from now. So getting professional assistance, regardless of where you get it from, is great. We're happy to help if we can. And, I hope the overview of this information was helpful. As a caution, this is very much a 30,000 foot view. The details are what'll kill you in this. And, if anybody has any questions, we are happy to help.
Thanks, Keith. I think you hit the nail on the head. This is a very highly individualized program. And, while the misnomer is out there that this is free money, this can definitely come back to bite you on the backside if you go on and think you can operate in your normal operations and everything will be forgiven as an act in course on the back end. Because with these programs, you got to remember the banks are very much adverse to the business owner. They are a creditor and you are the debtor in these things. So it might not be good to go this alone. Certainly contact the SBDC if you have any questions. Duran does a great job over there. Carlo, the state director, does a great job there as well. I know we got one more question here, a couple more questions. Gail asks, which loan should a partnership business apply for that has no employees and owns rental properties? That's one of those specialized questions, Gail, that we probably would need to review the books to give you a appropriate answer on. Obviously the PPP loans, they're going to be centered on companies that have payroll, right? So if you have a partnership business that owns rental properties, you might need the cash infusion that, the other loan might, give you some benefits from, but that's going to be something that we'd have to sit down and look at your books on to see what best program fits for you. Frank asks, so they aren't forgiving Fed taxes through PPP. You will get 50% of employee gross wages as a tax credit. I do understand things and probably will change, but we need to set up some accounting to take advantage of credits. I think you hit the nail on the head when you said things are going to change for sure. Keith, you want to comment at all on the federal taxes that he mentions?
Yeah, so the federal tax credits are there. The biggest caution I would have is understanding how they work with each other. While the credits, a good example, certain credits aren't barred because you're accepting forgiveness, though you can't take them during the forgiveness period, whereas the deferment is not available if you take the forgiveness at all. So understanding how they work with each other is going to be vitally important to make sure you don't end up accidentally double dipping.
Right. And that's a danger in all of this is there's a lot of misinformation out there. I can't tell you how many times I've been contacted by clients talking about a grant here or a grant there. People have got to remember that these are loans. There might be a mechanism right now which forgives them on the back end, but you need to treat them as they are loans because these are rapidly evolving on the regulatory front. And one misstep and not staying on top of the advancing regulations could prove to be very detrimental to your business on the back end. Julie asks, what do you know about the Louisiana loan program that's supposed to be available through economic development? Julie, this is probably a very, very small program. Keith, why don't you go ahead?
Yeah, these are available for up to $100,000 loans. Those are not forgivable. They will be paid back, but they're at reasonable interest rates. And those you do not have to worry about how they interfere with amounts you would qualify at a federal level. It's actually a very good program that the state's putting together.
It's a good program, but it's seated at a very small level. So what I would encourage you, if you have an interest in that or you have a client that has interest in that, definitely pursue that aggressively because they're going to run out of cash very quickly. In fact, the whole state's going to run out of cash very quickly as our economy is moving along here. Julie definitely gets the gold star for the most participation on this, so thank you, Julie. Any other questions? I think that wraps up the question portion. I want to give everybody one last chance to ask anything that's on their mind. But I think on that we'll probably wrap up. I want to thank you guys for the past hour. Of course, our email is david@snw.law and keith@snw.law. We're here to help you guys. We're big friends of the business community as business attorneys on both the litigation and transactional fronts. We do appreciate all the work that Duran and Carla do over there at the SBDC, and Brian, all the great folks up there that are hustling out there for you guys to keep you guys educated and put you in a position to succeed. If you have any individualized questions, feel free to reach out to us. Of course, we are lawyers. We don't encourage you to review legal documents without contacting a lawyer. So bring this stuff to the lawyer of your choice. So we're happy to help, but if you have a lawyer locally you work with on this, don't go it alone. You could easily step in it and could easily be problematic on the back end. With that, I want to thank everyone again. Keith, any closing remarks?
No, just thank you for your time. Again, very valuable and very good opportunities included in this act. I don't want to make anybody concerned about utilizing any of them, but you just have to be cautious as you do. And again, appreciate your time. Please feel free to reach out if you have any individual questions.
Thank you all. Have a blessed Easter and happy Good Friday. Go Tigers.